Hi, my name's Christopher Burgon. I own and run Christopher Burgon Solicitors. We are a specialist commercial and litigation law firm based in London. This video is one of a series of videos which we have recorded for people like you who are business owners, directors and shareholders who've decided that they want to separate from their fellow directors and shareholders, either buy them out or go their own way, and you want to do so without going to court. This is number 6 in a 7-step process. So let's recount how far we've got so far. So firstly, you and your business partners have decided that from that point onwards, the company will be run properly and that each of you will maintain the value within the company. Number 2, you've decided that control of the company is in the right hands. Now, if that means that your fellow director shareholders are still ripping you off, still undermining the company, then that has to be you that's taken control. If that's not an issue, then you remain in control, as do your business partners in the old arrangement. Number 3 is coming to a sense of the general value of the company. Where do the assets lie? Where's the value? Is it in the confidential information? Is it in the IP? Also, how does the behaviour or misbehaviour of your fellow director shareholders affect that value? Number 4, you've come to a decision about who's going to buy out who. Are you going to sell your shares to your fellow directors and move on, start afresh, or are you going to be the one that takes over the company? Based on that, number 5, based on all that work, you've come up with an expert valuation as to what your shares in the company are actually worth. You've done it in contemplation of court proceedings so that you have a fair value which includes any misbehaviour from the other side. If you've followed all of the steps in our process, you now come to number 6, which is negotiation. And if you have followed all of those steps, then this negotiation should be pretty simple, because you know who's going to buy whose shares, you know that they have the means to do so, and you have a strong indication of the value of those shares and the amount of money needed to reach a settlement. So negotiations really shouldn't be a problem. You've got expert evidence to guide you. However, it may be that there are still some matters which you need to iron out. Perhaps somebody is still disputing ownership of an asset, especially say the IP or the confidential information to a company. Who knows, there are a myriad of reasons, a million outstanding issues that need to be settled. Negotiation should be done on a without prejudice basis. Without prejudice means that you can make an offer, make a concession without being bound by it should you go to court. If in correspondence or if in meetings you can't reach a negotiated settlement, then you may choose to go to a mediation. Mediation is where everybody agrees to meet in a certain place at a certain time, and a third person, a mediator, is engaged, usually at pretty significant cost, to go between the parties to see if there's any kind of common ground and come to a final solution. Number 6 in the process, not quite the end. You've followed the process so far, you've gone a long way to finishing it. Number 6 is simply negotiating a final deal. If you have any questions about the subject of this video or about separating from your business partner generally, then please get in touch. Please go to the website. You can press the book a meeting button, which will take you directly to my calendar, and we can speak for 30 minutes. Or you can drop us a line by email or give us a call. If you've got any comments or any questions after watching this video, then please leave them below.